G'day everyone, and welcome to the third video for week 8 of our admin law course. This week we're looking at merits review, and as a result we're taking a close look at the Administrative Appeals Tribunal, the Commonwealth Government agency that has handled merits review since 1975. We're also looking at the Administrative Review Tribunal, which at the time of recording is soon to take over that role. We've already learned that each tribunal is an executive agency, which means it can make administrative decisions on their merits without offending the separation of powers. We've learned that each tribunal only has jurisdiction if there is a specific provision in an enactment that gives it that jurisdiction. We've learned that each tribunal has to overcome its expertise deficit, has to work out whether to conduct a review or a hearing de novo, and that each tribunal can take account of policy, but they're not bound by that policy. Finally, we've learned that each tribunal can affirm a decision, amend the decision, set the decision aside and make a new one, or set the decision aside and tell the original decision maker to make the decision again. In this final video, we're going to take a bit of a look at the procedures of each tribunal. What's the merits review process? There's a philosophy underlying the merits review process. The philosophy is that since administrative law is meant to be the process by which ordinary individuals can hold the government to account, the review process must be as simplified and inexpensive as possible, while still allowing justice to be done. There would be no point even having a review process if it was so darn expensive that only the wealthy could challenge decisions. Admin law can't just be for the rich. One of the stated aims for the new legislation creating the new Administrative Review Tribunal is to simplify processes. So how does it work? In virtually all cases when an administrative decision is made, the system provides for some sort of internal review. Most of the time, a decision document will actually tell people that they have the right to request that the decision be reviewed internally. No need for court, no need for the tribunal, it's all just done in-house. In most circumstances, you actually can't proceed to the tribunal if there's an internal review mechanism and you haven't used it. If your client comes to you unhappy about a decision and your research shows that there's an internal review mechanism available, think hard about how you structure your letter requesting the review. This is an opportunity for you to use your advocacy skills. If you just simply request a review, you can almost guarantee the reviewer will agree with the original decision maker. Instead, explain why the decision was wrong and why the decision should be changed. Government departments don't want to go to the time and expense of defending a tribunal claim if they can see their original decision was flawed. Also, remember that the reviewer is not limited to considering only the information considered by the original decision maker. If the original decision maker seems to have missed a key fact, don't miss the chance to provide additional evidence of that fact. More often than you might imagine, departments will change their view if you put the counter-argument persuasively enough. Let's say they don't though. The next step is going to be filing and serving an application. There are a few things to think about here. First up, the mechanics of the application process are quite easy. There are forms, both online forms and downloadable forms, which are intended for use by self-represented litigants. It's much easier, for instance, than trying to prepare a civil statement of claim or something like that. The reason for this is that in general, before the tribunal and its state equivalents, it's expected that most people will be self-represented litigants. The application process for the new ART is perhaps even easier. All that is required is that the application be in writing and contain all the necessary information. Second, in most cases, a review can only be conducted if the application is made within 28 days after the making of the decision which you wish to apply to have reviewed. So that normally means 28 days after the internal review decision is made within the department, because that's actually the decision you're going to be challenging. This time period is yet another thing which is not changing with the coming of the Administrative Review Tribunal. It's clause 118 of the new bill. Third, Bear in mind that the tribunals can perform both merits review and legal review. The application should set out one by one the legal problems with the decision and the merit problem. If your client is asking the tribunal to vary the decision or make a new one, the application should set out precisely what decision the tribunal is being asked to make and why that would be the right decision. Finally, the application will include all of the relevant documentary evidence supporting the claim. Now, we already know that the administrative decision makers are not required to follow the rules of evidence. It makes sense that the tribunal is therefore also not required to follow the rules of evidence. However, the tribunal is required to make a valid administrative decision, so they must take into account all of the relevant evidence and nothing that is irrelevant. Once the tribunal has received your client's application, the department will have an opportunity to respond in writing and will have a duty to provide the tribunal with the relevant documents supporting the decision. Once that has happened, the usual next step under the AAT has been to direct the parties to attend a conciliation conference. What happens there is that an AAT member sits down with the applicant and the department to try to resolve the dispute. An AAT conciliation conference is kind of like a mediation, but with some important differences. The key difference is that a mediator inevitably strives to be neutral in the dispute, not expressing opinions and not seeking to guide the parties to an outcome. An AAT conciliator is not necessarily neutral. That doesn't mean they pick a side. Rather, it means that the conciliator will not hesitate to point out what they consider to be weaknesses in either case, and they'll often gently advise which decision they believe the tribunal will arrive at. Many disputes before the AAT are resolved during this conciliation process. It's not entirely clear from the current draft legislation whether there will be a conciliation process under the new ART, but it's almost certain there will be. The entire momentum of the law in the last few decades has been in the direction of alternative dispute resolution processes, where the parties are given an opportunity to resolve matters between themselves with a minimum need for the intervention of a court or tribunal. It'd be staggering if the new tribunal didn't have some sort of a similar process. If conciliation is unsuccessful, well then we end up with a hearing before the tribunal. This is much like a trial before a court, although its processes are somewhat simplified. Very often, parties are represented by lawyers and often by barristers before the AAT. It looks as though this will continue before the new ART. A lengthy discussion of tribunal hearing procedure is really beyond this course, but after the hearing, the tribunal will issue a judgment, and most of those judgments are published. This is very useful because whilst strict stare decisis or strict precedent does not apply to the tribunal, previous cases will certainly provide you with some level of guidance as to how the tribunal is likely to handle your matter. Finally, if the AAT renders a judgment, it's still possible to appeal that judgment to the Federal Court or the Federal Circuit Court under the ADJR Act. Section 44 of the AAT Act begins, "A party to a proceeding before the tribunal may appeal to the Federal Court of Australia on a question of law from any decision of the tribunal in that proceeding." The new ART has a guidance and appeals panel to allow for an appeal within the tribunal system, but then essentially the same words that I've just read appear in Section 172 of the new bill. I'm sure by now you're getting the picture. While the new ART is being promoted as some sort of new institution, in most ways that matter, it really does just replicate what we already have. Appeal to the Federal Court on questions of law, of course, makes sense because ultimately the tribunal's decision is still an administrative decision being made by an executive body. So whilst we call it an appeal to the Federal Court, really and truly, it's just the initial challenge in court of an administrative decision. Carefully note, though, that you can only appeal on a question of law. It's legal review, not merits review, because it's a court. And for all the reasons that we've discussed right the way through this course, you can't get a court to conduct merits review. So this brings us to the end of week 8 of our admin law course. This week we've been looking at merits review, and in particular we've been looking at the Administrative Appeals Tribunal, which conducts merits review, and we've been comparing it with the new Administrative Review Tribunal, which is about to take over its functions. We started by talking about some of the challenges which a tribunal faces on merits review, its expertise deficit, the question of whether it should conduct a review hearing or a hearing de novo, and the question of how it should deal with policy. We've learned that each tribunal has broad powers in this review function. It can affirm the decision under review, amend or vary the decision, quash the decision, it can make an entirely new decision, it can remit the decision back to the original decision maker. We've learned about procedure. We've learned that the internal review is the first step, followed by an application, which leads first to a conciliation conducted by a tribunal member, and then if necessary there can be a tribunal hearing, potentially followed by an appeal on a matter of law to the courts. These tribunals really have revolutionised administrative law. For the first time there's a real system for merits review, and it's been developed in a way that makes it much more accessible to ordinary citizens, with a focus on resolving the problem. Next week, we're going to focus on the question of information. How can your client obtain information about the way in which the decision was made? See you next week.